It appears that MAiD is actually the outlier.
What are the specific sections of the Charter that could support a constitutional challenge?
Our right to life cannot be interpreted as a requirement to live.
Okay, well, so much there.
And yet, government after government did nothing, sat on their hands, because they didn't want to touch the issue. They wanted the courts to do it for them.
That clarified a lot of things that I wasn't quite sure about. Hi, welcome back. Last week I had such an interesting conversation with Eric Mathison. He is a clinical ethicist and a professor of philosophy. We talked about the ethics of allowing or not allowing mature minors to access MAiD. It was so interesting. I'll put a link down in the description. Today we're going to continue that conversation, but we're actually going to be talking with Emmett Macfarlane. He is a political scientist and a constitutional expert. Emmett, thanks for joining me.
Sure. I'm a political scientist at the University of Waterloo, and my area of research really focuses on the intersection of constitutional law and politics. So a lot of my work looks at governance issues, institutions like the Supreme Court and Parliament. And I've been doing a lot of work in recent years on things like constitutional change, free expression. But throughout my entire career, one of my main areas of focus has always been the Charter of Rights and its impact on public policy. Yeah.
Okay, that's excellent. I think this is one of the areas that I have the least amount of experience in. I'm a registered nurse, so I know a little bit about some ethics stuff and definitely some of the medical side, but the law and constitution and how court cases unfold, particularly obviously when we're talking about MAiD, I don't know as much as I should. So I'm really hoping to learn a few things here. So thanks for doing that. So I thought maybe it would be helpful to do maybe a quick overview of the Carter v. Canada case. I'm particularly interested in how broad or not that scope of that decision was. Are you able to just give a kind of a brief overview of that?
Sure. Yeah. I mean, the background to the Carter case is a 1993 case called Rodriguez, where the court split by just a single vote in upholding Canada's prohibition on what the law called physician assisted suicide. Um, 20 years later, it became clear that there was an opportunity to kind of revisit that precedent. One of the big factors was Section 7 of the Charter, which is our right to life, liberty, and security of the person. The doctrines around that had really evolved in a way that lent itself well to a challenge. And basically, the challenge came down to, whether an absolute prohibition on medical aid in dying violated the charter, and whether it could be upheld as reasonable. And so in 2015, the Supreme Court gets this case, and it rules unanimously that the prohibition under the criminal law was indeed unconstitutional. One of the things that helped here was that we had evidence from other countries in 2015 that we did not have in the early 90s, that some of the arguments about slippery slopes, about the vulnerability of certain people in the population against allowing medical aid in dying, that safeguards could be actually put in place to protect against abuses, coercion, and the like. And the court found that body of evidence very persuasive. And so the basis of its decision was really, on the one hand, under the law and how we understood Section 7 rights under the Charter, that a prohibition was actually harmful, that it was both arbitrary and grossly disproportionate under Section 7 in terms of the harms imposed by effectively compelling people to continue to endure intolerable suffering from irremediable medical conditions. And then the evidence that you could actually permit this as a medical service while still safeguarding vulnerable populations. And the court basically set out a scope of permissible activity along those lines. And so in the context of the Carter decision itself, and given who the plaintiffs were, the court basically said that anyone who is an adult, who is capable of informed consent, and who is suffering intolerably from an irremediable medical condition, effectively has the right to access this service. Now, the court did not go into a lot of detail defining irremediability, although we know it includes both. We know that the suffering can be either psychological or physical in that sense. The court did not deal with a whole host of subsidiary issues. So, because of its reference to adults, the question of mature minors was left completely open, as was the question of advanced directives. And we subsequently, really, in terms of Parliament's eventual response to Carter, another remaining issue was, does this apply to instances where the sole condition is a mental health illness?
Mm-hmm.
And these are some of the subsidiary debates that we've had since Carter. But Carter opened the door to effectively requiring that adults with irremediable medical conditions causing intolerable suffering be eligible for medical aid in dying.
Okay, so if I understand that, so when a court makes a decision, they depending on how they frame their response, they could say it's wide open, using deliberate language to sort of make it sort of MAiD is legal generally kind of across the board, or in this case, they've used specific language to really frame the decision based on that case without sort of automatically saying it's now allowable in all these other areas. Does that make sense? Am I understanding that right?
Yeah, I mean, theoretically, courts can provide what are called constitutional exemptions for the plaintiffs immediately before
Right.
them.
Mm.
But here you had a constitutional challenge against the criminal law at stake. And so the court, in 2015, it was very unlikely the court's approach would have been a very narrow remedy only affecting the plaintiffs. It was a decision about the state of the law. They ended up giving Parliament 12 months to, in effect, respond to this decision. That's called a suspended declaration of invalidity. And what it really does is technically the law stands for another 12 months while Parliament figures out how to deal with this so that there's not a vacuum in the law. In this case, the court didn't necessarily have to go that route. Um, it could have read in its own remedy into the law and basically say, well, we're gonna interpret the law and require all the other courts in the land to interpret the law as allowing this exception. But normally, the court will, in fact, leave the law-making part of this to Parliament, as it did here. And so the law was, in effect, struck down. And the court wasn't comfortable just saying the law is unconstitutional. The court wanted to offer us some parameters
Right.
around this because, of course, there are a whole set of criminal laws relating to homicide that are implicated in the MAiD context, because you're talking about, even though people may be seeking out this as a service, and it's really about the medical professionals performing the service and making sure they're not criminally liable. The court had to make references to things like capacity to consent. Otherwise, a whole other bunch of other provisions of the criminal law would have been implicated, and there would have been
Okay.
confusion in that area.
Right. Okay. Thank you for that. Okay, that clarified a lot of things that I wasn't quite sure about. So that's good. So maybe we can just jump right into mature minor. So how does the mature minor doctrine fit in with the broader framework of Canadian constitutional law, particularly the Charter of Rights and Freedoms? And have there been any Supreme Court cases that have recognized the rights of mature minors to make medical decisions, and how have those rulings sort of shaped the legal landscape?
Sure, yes. So the leading case on this is a Supreme Court decision that's not that old. It's from 2009 called AC versus Manitoba.
Okay.
The concept of mature minors is much older than that, and it goes back to, it has a tradition in other countries, including Britain. And it was part of our common law before this particular judgment. But the court was confronted in 2009 with a Manitoba law that basically set an age cutoff on when there would be basically an assumption that someone had capacity to consent. And Manitoba selected the age of 16. So if you're 16 and older, the assumption going in is that you have a capacity to consent to medical treatment or to refuse medical treatment, unless it could otherwise be demonstrated that you don't have capacity, in which case you might have parents who make the decision for you, or in rarer cases where say doctors and parents or caregivers disagree, the state has to step in and make decisions in the best interest of the individual. The question in this case concerns someone who was younger than 16 who wanted to refuse blood transfusions. They had a condition causing internal bleeding. The doctors had reasons to believe this could get quite serious, and in fact, at a certain point, became concerned that that her life would in fact be at risk if she did not receive transfusions. The patient here is a Jehovah's Witness, as were her parents, and wanted to refuse any treatment whatsoever. What the Manitoba law did was basically assume anyone under 16 doesn't have capacity to consent, but the courts, in fact, not just the Supreme Court, but in the same case, the lower courts leading up to it, basically read the law as, well, it actually provides an opportunity for mature minors to demonstrate that they have some capacity. And if they demonstrate that they have capacity to make an informed judgment, that should weigh into the decision. But a majority of the court also made it quite clear that the mature minor concept doesn't mean that recognition of capacity of that individual like automatically makes them equivalent to an adult. The law in Manitoba still required that the best interests of a child be taken into account in any final determination. So it gets a little complicated because once a mature minor can demonstrate capacity, that's not necessarily the end of the analysis. The court basically said that this operates kind of on a spectrum. And if capacity is demonstrated, that should be given really great weight in any final determination. But we recognize that there is an evolution in people's maturity. And when you're thinking about capacity to consent, you're thinking about whether an individual is capable of understanding the information being presented to them, the consequences of certain decisions, and really being able to make an informed judgment about what decision they end up making. There isn't a magic moment where an individual goes from not having capacity to suddenly having capacity. It's part of our development as people, and the court kind of recognizes that. And so the court said that, the law, the legislature in this particular case, but the law generally as the common law recognizes that the state also has an interest in protecting children. And can make medical decisions along that basis. So in this particular case, in fact, you have a judgment that yes, this particular patient actually did have capacity, and yet the lower court was still correct in making a determination that they be given blood transfusion, which in this case they were, well before the Supreme Court ever got to the case, because this is a long time after. It takes quite a while for cases to work up the system. And so this is an important concept in law with regard to patient care and decision-making autonomy. It is, there aren't a ton of cases, but where we tend to see cases is often where spiritual beliefs relating to medical treatment come into play. So there are other cases involving Jehovah's Witnesses. There are cases involving Indigenous peoples, and it's often the case where both the child and the parents have the same nexus of beliefs, and it's the state that is kind of the antagonist or protector, depending on how you see these things. That wants to protect what the interest of the child. So it can get quite fraught and controversial in some of these cases, because there are cases that involve like cancer treatment and whether that should be pursued versus, particularly treatments that conventional Western medicine recognizes that there's a scientific consensus about the possibility of treatment being successful versus medical beliefs that maybe aren't scientifically proven. But in these cases, we see different outcomes depending also on what is the effect of what is the likely outcome of the treatment. So in cases where, even in cases where, consent has been determined, um, if the state won't be permitted to intrusively impose a treatment that only has like a 30% chance of success. Because so in other cases, courts have ruled, no, this would be too traumatic to the child. So even though they are very likely going to die by not undergoing this treatment, we're not going to impose it because it's far from guaranteed to actually save their lives anyway. And this would just be putting them through psychological suffering at what could be the end of their life anyway. So we've seen different outcomes depending not just on that capacity question, but on the full context of the case.
Okay. Well, so much there. So it sounds like that in that particular case in Manitoba, the person was deemed to be, yes, they do have decisional making capacity, but in the best interest of the person in this case, they did end up having the blood transfusion. So there's that balance that's being made.
Yeah, and so the structure of the law actually probably determined the outcome here, because had they been over 16, they likely would have been respected. So the court was very careful to say it's not just an age cutoff, it has to be contextual. But the age cutoff actually still matters at the end of the day, at least in the context of the Manitoba law that was at stake there.
Right. Okay. Yeah. Okay. So you also said a few things about the likelihood of success in the treatments that are being imposed, and with the vast majority of MAiD cases being people who have a reasonably foreseeable natural death, I'm wondering what the reasoning in those cases, like how they could be applied to a case specifically challenging that exclusion of mature minors from MAiD.
Yeah. So this is where it gets potentially really interesting, is that I think the entire analysis relating to best interests of the child, in some cases where a child has capacity to consent, not just to consent to, but to seek out MAiD, what is their best interests? So some people might say their best interest is fighting to live under any conditions, and these might be people who generally oppose MAiD. But others might, in fact, say, actually, in here, the best interest of the child is not to endure intolerable and irremediable suffering, but to get MAiD. And in that frame, arguably, MAiD for mature minors is even less controversial than in some of these other contexts where it's about whether they're refusing life-saving treatment, particularly in contexts where a patient may be relatively close to death. They have a terminal disease. They're suffering intolerably. The outcome is there. They just don't want to go through that last stage of intolerable suffering. And so the mature minor concept as applied to MAiD in some ways leads itself to a fairly straightforward legal analysis under both Section 7 of the Charter, under equality rights, Section 15 as well, because everything the court said about a prohibition on MAiD applies to children. The court determined that an outright prohibition is cruel for people under a certain set of factors. That certainly applies just as much to children who can suffer like anyone else with certain medical conditions. And so the logic becomes, in some ways, it militates quite in favor of opening this door. I think that the challenge is more moral and political, because a lot of people don't like thinking about this in the context of people who are under 18. And right now we have a law at the federal level that does restrict access to MAiD to people 18 and over. But the mature minor context is one that I think courts would be quite challenged to not extend access if they are faced with a case particularly a case of someone who is terminal, who has capacity to consent and wants MAiD. I don't know how a court in this country can read the Carter decision, read the Trutron decision out of Quebec, and not arrive at an outcome where, in some cases, mature minors should have access to this service.
What are the specific sections of the charter that could support a constitutional challenge to the exclusion of mature minors from MAiD?
So I think the two main ones are Section 7, which recognizes our autonomy over decision making, particularly our physical security, but also decisions governing our life, and that extends to the end of our lives. The Trutron judgment out of Quebec, which actually struck down elements of the federal government's MAiD regime that were challenged on the basis of this requirement that the government added that people seeking MAiD have a reasonable foreseeability of death. That basically it's not quite a requirement that they have a terminal illness, but that they be in some sense close to death to access MAiD. And the court made, I think, a pretty strong point that, in fact, in some ways, that prohibition is actually even more cruel for someone with an irremediable decision, but who has a longer pathway to death.
Yeah.
And that logic applies, I think, equally to mature minors as it relates to Section 7 and our bodily autonomy and our right to life. Our right to life cannot be interpreted as a requirement to live.
Right.
And I think both Carter and Trutron make that case that the state's imposition here in contexts of intolerable suffering is just manifestly unjust. And so there's no reason that doesn't extend to children, at least to mature minors who can properly consent and make decisions about their autonomy. The other main section is equality rights under Section 15. Section 15 protects against all sorts of discrimination, and the main one here of relevance here would be age-based discrimination. And the mature minor concept is actually a kind of a perfect analysis for whether discrimination is occurring, because on the one hand, we make all sorts of things contingent on adulthood or on some age age cutoff, because we recognize that, generally speaking, children aren't developed, don't always understand the consequences of their action, need to be protected by particularly their parents, sometimes by state actors or the state itself. But in the context of a medical decision, the mature minor concept makes it quite clear that we should be considering the judgments of those individuals who can demonstrate a capacity for consent. And that can extend to people as young as 12, 13, 14 in certain cases. And so the equality rights analysis in a potential challenge could be just as important as the Section 7 analysis on autonomy.
Okay. I just want to clarify something that make sure I understand this right. Just about Section 7. So it's life, liberty, security of person. I think the life and liberty part is easy to understand, but am I right to understand that the security of person also includes the right to be free from unnecessary suffering? I believe I remember reading that at some point.
Effectively, right? And so Section 7 has its origins under the legal rights section of the Charter. And initially it was thought to really be about what can the state do to you in the context of like the criminal justice process,
Right.
the legal process. And it's been expanded to predominantly criminal laws that might impose physical or psychological suffering. And so some of the famous cases in that vein include the 1988 abortion decision in Morgenthaler, where a law that was quite restrictive in terms of people being able to access abortion services actually created delays and wait times that the court determined imposed physical and psychological risks that were unnecessary. It's been used in the context of the federal government's attempt in 2008 to shut down the supervised injection site Insight in Vancouver. finding that that was an arbitrary decision that would have imposed suffering and led to potential overdoses and even deaths. It's applied to laws that made it more risky for sex workers to engage in their profession in a case called Bedford in 2013. And so it was a very natural, by the time you get to Carter, you had all these precedents about how security of the person, that part of Section 7 operates. And if this basically, if the state in pursuing some objective, even an objective that's about protecting vulnerable people, if in doing so they are causing grossly disproportionate harms to people's security of the person, that's going to be unconstitutional.
Right. Okay. Thank you. Okay. Are there, when these things go in front of the court, do they have to sort of pick a section or an argument that they're making? Can they make multiple? Can they say this is against 15 and 7, some combination?
Yeah, so it's very common for lawyers not to necessarily take a throw everything at the wall and see what sticks point, because of course we'll get annoyed at that, but it's very common to actually go through all of the relevant arguments. And so even Section 7 will get broken down into its constituent units sometimes. There'll be a right to life analysis, a right to security of the person analysis separate from that. But you would expect in almost any case involving MAiD along these lines that they would rely on both Section 15 and Section 7. Depending on the circumstances of the plaintiff, you might have other rights implicated here. You might talk about religious freedom in certain cases, for example, or even freedom of conscience, which doesn't get a lot of attention in our law, but might be relevant to this sort of a decision.
I think so. Can you explain what Section 1 of the Charter is, and does that have any bearing here at all?
So Section 1 recognizes that all of the rights listed in the Charter can be subject to reasonable limits in the context of a free and democratic society. It also requires governments to justify those limits in that context. So the courts have developed basically a proportionality test to determine whether or not, even when a law limits a right, is it doing so in a reasonable way? And so the court will look to whether there is a pressing and substantial objective at stake that the government is trying to pursue, whether the law that they enacted to meet that objective is actually rationally connected based on what the law is trying to do to that objective. And so that's another way of saying if the law is arbitrary in relation to the objectives, it's not going to hold up under Section 1. And then there's basically a minimal impairment test. So does the law interfere with the right as little as possible in order to meet the objective? And there you have kind of questions of whether the law, applies to circumstances beyond what would actually meet the objective. Is it overbroad in that sense? What is interesting in this context is that in Section 7 cases, a lot of that work of Section 1 is actually also internal to Section 7. So in Section 7, they're looking to see if not only if the right to life, liberty, and security of the person is violated, but is it being violated in accordance with the principles of fundamental justice?
Yes.
And this is a bit into the weeds of the law, but the principles of fundamental justice that the court has developed is basically, is the law arbitrary? Are the effects grossly disproportionate in terms of the harm involved? Is it overly broad in meeting its objectives? So it's very similar to those Section 1 questions. And the result is that in almost every case where Section 7 has been found to be violated, it never gets upheld under Section 1 because the Section 7 analysis does all that work. Whereas with almost every other charter, right, Section 1 is really important. It's about could this law have really been designed differently to not impair rights as much and still meet the same objectives? And that's something that the courts often have to weigh. Unfortunately, it means the courts are often getting really deep into policy analysis more than really a technical legal judgment.
Right.
All of the, when you're analyzing, whether a law is proportional when it's violating a right, you can kind of craft that analysis to meet the outcome that you think is just. There aren't really any objectively correct right or wrong answers there. It gives the courts a degree of discretion here. And the courts have kind of oscillated. Sometimes they're quite deferential to government objectives, and sometimes they are really not.
So what you're describing to me sounds like an examination of the legislation, which is essentially a set of eligibility criteria, safeguards, and then by nature of the way it's written, some exclusions, and seeing if those are the minimum necessary in order to allow this to be accessible to people, but with the least amount of restrictions, or the least amount of safeguards. Is that a layman's understanding of that?
I think that's a good way to put it. I think in the MAiD context, as it applies to mature minors, the Section 1 analysis is actually pretty challenging for anyone who wants to see the exclusion upheld.
Okay.
Because once you have this landmark judgment in Carter that says imposing intolerable suffering on adults is unconstitutional for these reasons,
Mm-hmm.
how you can make an exception for mature minors it becomes difficult to see, really, right? It's hard to see the reasonableness of excluding mature minors from this, other than our very natural emotional reluctance to want to think about it, because it's obviously a very tragic thing.
Yeah. Okay. So it sounds like the reasoning behind the Carter decision can in some way be extended to mature minors. But it's probably very unlikely that we would see a challenge just based on the nature of, a 16 or 17-year-old reaching end of life. They don't have time or effort likely for that. It'd be very difficult to find a case that someone would want to take forward with that. Can Parliament just go ahead and include, folks with mature minors in certain situations? And is there any issues with that, doing it without sort of the courts weighing in first?
Yeah, and so make sure I answer that question, but I want to go to your premise first.
Okay, good. Yeah.
You don't necessarily need a direct plaintiff who's in the middle of trying to seek MAiD, who's literally possibly on their deathbed, to challenge the law. Yeah, you can have people take up the case on their behalf.
Right.
Someone could even theoretically seek to pursue this by obtaining what's called public interest standing. So you get recognized as someone who can bring this case just by virtue of it being a really important public issue. So I wouldn't rule out a challenge, at least on that basis, that you might not have the right plaintiff. I think it's possible that this could move forward in some fashion, and even by an interest group like the Canadian Civil Liberties Association or some such group. One of the frustrating things is sometimes governments, in the act of being just very deferential to courts, they end up implementing exactly what the court indicates is kind of the minimum threshold to make sure rights are protected. There's nothing stopping governments from actually taking a more liberal approach and actually protecting rights on its own initiative. And some would say that this is exactly what should be the case, that if anything, we've been having this debate about whether we're going too far with MAiD. But I think a lot of people who have thought through some of these issues say, in fact, we are still excluding too many categories of people, not only mature minors, but people whose sole condition is mental health, or we're not allowing advanced directives as in as fulsome a way as we might. So there's nothing stopping Parliament from pursuing this with more vigor. You could see charter claims and litigation in reverse, right? So unless Parliament really carefully tailored a law to mature minors, someone who is more of an opponent of extending MAiD in this fashion might say, no, here's where you are clearly risking vulnerable people being subject to coercion in some fashion. So it's not as if it's not possible for there to be challenges on the opposite end. In fact, even sometimes invoking this very same sections of the charter to do so. That the opponents of the current MAiD regime think that there are too many vulnerabilities in the system, and they would challenge it on Section 7 type grounds or equality rights grounds. So you could, anything Parliament does could potentially result in litigation, is what I'm saying. But in general, there's nothing stopping Parliament from moving on this. I think the real challenge has been, as it always has been, is that Parliament and governments in particular don't like expending political capital on these controversial social issues. And that's the very reason that the absolute prohibition on medical aid in dying stood for as long as it did. We had public opinion research in the early aughts showing that upwards of 85% of Canadians opposed a full-on ban.
Mm-hmm.
And yet government after government did nothing, sat on their hands because they didn't want to touch the issue. They wanted the courts to do it for them. And that's why I worry that this sort of thing actually requires litigation. And we have been pushing a lot of these social decisions onto courts instead of dealing with them in a responsible way in the political arena.
Mm-hmm. So when you're mentioning the legislation then being possibly followed by a court challenge, immediately made me think of some disability groups that are challenging right now the not reasonably foreseeable natural death inclusion. So what we often call track 2. I don't know if you want to say anything about that or
I mean, I
comment on
think
that at
really
all.
their claim rests on the idea that if the government had only appealed the Truchon decision, which was a lower court judgment out of Quebec, that there might have been a different outcome. And so these litigants are basically hoping that the Supreme Court would not uphold the Truchon judgment and say that, in fact, yes, reasonable foreseeable deaths are actually an integral part of maintaining some protections for vulnerable people in the MAiD regime. That's what their legal argument ultimately rests on, and it's a dubious one in my view, only because I think the Truchon decision really closely followed the natural logic of the Supreme Court's own Carter judgment in 2015.
Let's say there were a constitutional challenge. Do you think the courts would require or would weigh in on those additional safeguards or any additional safeguards because of the vulnerable nature and that with mature minors?
I'm not sure that the courts would want to get super prescriptive. The question would come up if, in the context of the litigation, is there new evidence adduced that some type of extra special protections for mature minors are warranted in the MAiD context, or whether the regime that is currently in place to ensure things like irremediability, capacity to consent, and those things that apply to adults, whether or not it's logical to just have those apply in the mature minor context. Despite some of the media panic around MAiD in Canada, where they really leverage quite heavily anecdotal stories about the evils of the system, there isn't actually any robust evidence that vulnerable people are being coerced into MAiD, or that there are any really fundamental problems with the MAiD regime. And absent that evidence, I think the courts would be unlikely to start piling on new safeguard requirements. The question would really be, in the court's judgment, about whether there's anything distinguishing mature minors as a concept in the law in the MAiD context versus all of the other medical, even life and death medical contexts to which mature minors already apply.
So you're saying that are you saying that in considering mature minors, a court would look at how MAiD has been managed throughout the country, recognizing that there are very there's very limited, if any, evidence of vulnerable people being talked into it or forced into it or any of those sort of things, and then applying that to the idea of mature minors as a group that might possibly need protection from the way the law is written now, and maybe determining that no, that's not the case.
I mean, I think that's how I would see it logically playing out. I don't know whether in the next few years we will have more robust evidence in either direction.
Yep.
We do have reports and data that are highly suggestive that people like Eric Mathison have explored that really, I think, bolsters my confidence that the MAiD regime in Canada is actually quite a strong one in terms of the protections it provides. One of the interesting things that might come up are those really fraught cases where a mature minor is seeking to pursue MAiD over the objections of their parents. And then what the state role and what the physician's role becomes in that very difficult, challenging context. That doesn't arise in the context of adults seeking MAiD because their families have ceased to have any authority or influence over their medical decisions.
Yeah.
But in these mature minor cases, in at least some of the more high profile ones, it's been cases where it's both the parent and the child seeking to refuse treatment that doctors think are warranted, and the state has stepped in the child's best interest. So I don't know how a court will deal with a potential circumstance where parents who are still legal guardians, who still get to be reasonably informed about their child's medical status and have input on these decisions in the child's best interest, how that should inform fully a mature minor context, because we know that from the existing jurisprudence, all of these factors are part of the overall weighing of what should happen in that question of capacity versus best interest that comes into play. My personal view is that in the MAiD context, the wishes of the individual predominate. And in fact, in both the context of consent and capacity, and in that issue of best interest, they both actually lean in that one direction, which is actually not true in other contexts, where best interest is kind of competing against the wishes of the individual in the context of refusing treatment.
Yep.
So there are unique features to this in the MAiD context that will need to be reconciled with the law, but I think they tend to lean in the direction of allowing mature minors access.
Yeah. I'm just understanding the unique nature of this, and you saying that often it's the minor and the parents being on the same page. Are there any examples of cases where there was that sort of separation in desire, where a mature minor might want one thing, like say refusing a blood transfusion, and the family saying, no, we want you to have it? And any examples of that at all? Or are we sort of charting kind of a new area here?
I'd be surprised if there wasn't, but most of the high profile cases I've read about tend to be also religious freedom cases where the child and the parents share a nexus of spiritual beliefs. There was one case, and I think the Supreme Court talks about it in the AC versus Manitoba decision. There was a case where parents were divided. The two parents were divided, or they were initially on the same page, and like the father ended up switching. And then it's still kind of a best interest versus what is the mature minor saying. And that can happen in cases where the child is found to have capacity, and in cases where the child is not found to have capacity, and what should the treatment option be? And then you're weighing again, how likely is the treatment to be successful? How invasive is it? Is this a life-altering or life-saving thing?
Right.
But a lot of that is very different in the MAiD context, where presumably we're going to be talking almost always about cases where there's a terminal illness involved, I think.
Yep. Yeah. Just to jump back to something you said earlier about the robustness and how safe it seems like the MAiD eligibility criteria that are. I think there's a perception, and I guess part of it's true, that I think the MAiD community is not open to a lot of changes to the criteria and safeguards, but I think that's because they feel like they're pretty robust as they are. But I think there's an openness to, if there were evidence that we needed additional safeguards or there needed to be different protections for different groups, that people who do support MAiD are quite open to that. And there's no opposition in principle to additional safeguards. It's just we need evidence to know that these are actually needed. I guess going back to what you're saying, the least restrictive policy. So it'll be interesting to see how that kind of is operationalized if mature minors are ever granted access.
And in the inverse, there's still some questions around some of the protections imposed by the federal law now that it was amended to have those 2 tracks. And with regard to people whose death is not reasonably foreseeable, they're still imposed a wait period that seems insensitive to the different contexts of individuals, and might itself be arbitrary in certain cases. So there are certainly further discussions to be had about safeguards, both in terms of whether the system is monitoring for abuse in as robust a way as it could be, but also there might be safeguards that are still actually rights infringing and unnecessary in some sense.
Interesting. Hadn't thought of that. Okay. I know, just being mindful of your time, just maybe one more question. If mature minors were to be granted access through a court ruling, would that sort of have any broader legal or policy implications for other areas of healthcare or decision-making involving minors?
I think it's an excellent question, but I'm hard-pressed to think of one because I actually think it appears that MAiD is actually the outlier with respect to mature minors, that in all the other medical contexts about receiving services or treatments in the healthcare setting, we already have an approach that recognizes and protects mature minors to the extent that it does. That as long as they are assessed as having the capacity for consent, they get to make these judgments. And where it gets tricky is where you're dealing with those situations that are really about either life and death or quality of life, where the state is stepping in for the best interest of the child, is where it gets fraught. But otherwise, there's probably 100 cases a day in this country where mature minors are actually exercising some autonomy in a healthcare setting somewhere, and it's uncontroversial. And it's only in MAiD that they are completely, in an absolute sense, prohibited from doing so. And so I think MAiD is the exception.
That certainly sort of illustrates the idea that it might be difficult to justify excluding people with mature minors just as a broad prohibition.
I think so.
Thank you so much. This was so interesting. I have so many more questions, but I just want to thank you for the time that you've taken already. Did you want to let anyone know how to find the work that you're doing or promote anything while you're here?
Sure. I currently write a newsletter under Substack that's called Defending Canadian Democracy. I post regularly on broadly on Canadian politics, but also on often enough on constitutional issues as well.
Perfect. All right. I'll put some links to that. Thank you so much. I really appreciate it.
Happy to be here.